Hello everyone, I'm Anuj Nakade and you're watching Livelaw. In this video, we bring you an update from a hearing regarding the rights of sex workers that happened in the Supreme Court on Thursday, the 4th of May. But before that, we will tell you the history of the case. The story is a little long and deals with a dark truth. The dark truth is that it is difficult for sex workers or people who are rehabilitating after being forced into sex work in this country to live dignified and safe lives. Many of our viewers might be aware that sex work is not illegal in India. However, trafficking and running commercial sex work establishments such as a brothel is illegal. This means that sex workers are not criminals but often victims of a crime. The story of this case starts in 1999 with a brutal murder of a sex worker in Kolkata. The reason for this murder was reported to be that the accused was a prospective client and the victim refused to have sex with him. The trial court convicted this man of murder. Then the convict approached the Calcutta High Court with an appeal. But the Calcutta High Court also upheld his conviction by the Sessions Court and dismissed the appeal. Then, in 2010, an appeal was filed by the convict in the Supreme Court. But the Supreme Court also dismissed the appeal in 2011. But while dismissing the appeal, the Supreme Court took note of the troubles faced by sex workers across the country. The court also observed that the sex workers have the right to live with dignity under Article 21 of the Constitution like any other citizen in this country. The court said in this order, and I quote, "Sex workers also have a right to live with dignity under Article 21 of the Constitution of India since they are also human beings and their problems also need to be addressed." The court said that a woman is compelled to become a sex worker because of poverty. If an opportunity is provided for these women to undergo vocational training, they will be able to earn their livelihood through such skills or training instead of selling their bodies. Considering this, the Supreme Court issued directions to the central and state governments, telling them to prepare rehabilitation schemes for sex workers, which will provide technical and vocational training to enable them to leave sex work. In the same year, that is in 2011, the Supreme Court also constituted a committee headed by senior advocates Pradeep Ghosh and Jayant Bhushan to advise on the issues of prevention of trafficking, rehabilitation of sex workers wanting to quit, and helping sex workers with conditions that allow them to live with dignity. This committee submitted a full report in 2016 with amendments to be made to the Immoral Traffic Prevention Act. In light of the report, the Supreme Court directed the central and state governments to provide ration cards to all sex workers on the basis of their identification by the National AIDS Control Organization, along with providing them technical and vocational training. However, in 2020, the COVID-19 pandemic arrived. During the pandemic, an application was filed by the Darbar Mahila Samanwaya Committee in the Supreme Court. The Darbar Mahila Samanwaya Committee is a collective of 65,000 sex workers, and the organization works towards providing rights to sex workers. Their plea in this application highlighted how despite the Supreme Court's orders in 2011 and the committee's report in 2016, sex workers still were not provided ration cards. The pandemic had affected sex workers very strongly, and the central and state governments had not provided access to the community as per the Supreme Court's order. A bench headed by Justice L. Nageshwara Rao told the central and state governments again to provide ration cards and voter IDs to all sex workers. The court said, and I quote, "As this court has directed the state governments and union territories to issue ration cards and identity cards to sex workers almost a decade back, there is no reason as to why such direction has not been implemented till now. Right to dignity is a fundamental right that is guaranteed to every citizen of this country irrespective of their vocation." Last year, in 2022, the Supreme Court noted that no amendments or new acts were passed in light of the recommendations of the committee in 2016. So, the Supreme Court passed detailed directions. These directions were put in place till an act is passed by the central government. Now, yesterday, on the 4th of May, a 3-judge bench of the Supreme Court comprising Justice B.R. Gavai, Justice Vikram Nath and Justice Sanjay Karol heard a specific issue in this matter. The issue before the court was the treatment of women who are rescued from sex work and are put in protective homes which are created by the government under the Immoral Traffic Prevention Act. Senior advocate Jayant Bhushan appeared as an amicus curiae in this matter. Amicus curiae, as most of our regular viewers might know, is a lawyer who is not representing any party in a case, but assists the court as an expert on the matter. It literally means friend of the court. The amicus curiae pointed out to the court that most states in their affidavits have told the court that the women in these shelters do not want to leave. He then alleged that this is not true. He said, and I quote, "Surprisingly, many states have submitted that they found out that no one wants to leave. This is against the ground reality. Most women would not want to be kept in these protective homes." Senior advocate Bhushan also pointed out that there are adult women who are held in these protective homes like prisoners. These are adult women who are refused to let go out of their shelter homes and are constantly treated like criminals. He further said, and I quote, "Adult women wanting to leave cannot be held against their will in these protective homes. These protective homes are like jails. Most of them do not want to be there. These are adult women, not criminals. States should not be allowed to treat them in this patriarchal manner and say this is for their protection, even when these women are not willing." Senior advocate Anand Grover, who was representing the Darbar Mahila Samanwaya Committee, also agreed with the amicus curiae. He pointed out to the court that under the Act, the protective homes are mandated to keep the rescued women for only 3 years for vocational and technical training purposes. He said to the court, and I quote, "It is shocking that women are being kept beyond the period mandated under the Act, which is 3 years." In response to the above submissions, advocate Aparna Bhatt, appearing for one of the protective homes in Hyderabad, has submitted that the women rescued from brothels want to go back, but they don't know what's good for them. Her exact words were, "I can say with experience that all the women who are rescued from brothels on the date of the rescue say that they want to go back. This is because they do not know any better and their belongings are also with the brothel owners." In this hearing, the court also inquired about the Sex Worker Rehabilitation Bill, which was supposed to be introduced after the 2016 committee report was given to the government. The Additional Solicitor General, appearing on behalf of the central government, said that a bill was proposed and was sent to the relevant stakeholders. Upon hearing this, the court said, and I quote, "This needs consideration. When we take this up, we will see if the Parliament has passed an act. If they have not, we will consider passing orders with respect to this." The court has decided to hear this matter again soon. If you want more details, please visit our website at www.livelaw.in. We will also leave a link down in the description to the full article. We intend to keep you updated in this regard. Please subscribe to our channel and press the bell icon for notifications. If you found our detailed breakdown interesting, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more interesting ways. Thank you.